Now, if we do everything right, we're not going to have a will. If we do everything right, there's not going to be a probate, and the will will never see the light of day. Very common misconception. There is no, quote, reading of the will. People don't gather in a musty lawyer's office and you get nothing, all right? You get my love and affection and nothing. You know, that doesn't happen. What happens is, if there is going to be a probate, the original will is attached to a petition for probate. It's filed at the court. There is a hearing. At the hearing, the personal representative, the executor, is sworn in, and then they set about paying the debts, collecting the property, and distributing it and reporting everything back to the court. And they all do it. The will is the document that they use. Without the will, you have to go to what's called the intestate succession statute, and the intestate means without a will. It's the distribution statute in Oklahoma that says if you die and you have a spouse, then the spouse gets, okay, here we go. The spouse gets 1/2 of the jointly acquired property, and then the other half of the jointly acquired property and all of the separate property of the deceased are divided amongst the surviving spouse and the children of the surviving spouse. And if the surviving spouse didn't have any children, did the children leave children? All right, if there's a predeceased child that left children, then that is divided to the grandchildren. Now, if there's no children and grandchildren, then you go to the parents. If one or both parents are alive. No parents alive, brothers and sisters. No brothers and sisters, nieces and nephews. Now, when I was in law school, the way it was described to me and the way I always remember it is it's an umbrella formula, okay? It's parents, brothers and sisters, nieces and nephews. If you don't have anybody, grandparents, aunts and uncles, cousins, and down. If you don't have anybody, then you go up another generation, and you keep doing it until you hit someone that's living. And then that's the level that gets the distribution. Okay. Now, a will can be what's called holographic. A holographic will must be entirely written, dated, and signed by the hand of the person. Now, that's very important, because what's called a statutory will, if you go to your lawyer and have a lawyer draft up a will, that's called a statutory will, and there are certain requirements for that. But a holographic will, you actually have to write it out yourself. You cannot ask somebody to write it for you and then sign it. You cannot write it and then sign it and then fail to date it, okay? You have to put a date on it. It has to be entirely in your handwriting, and it has to be your signature. If all that's met, then that is a valid will. It does not have to be witnessed. It does not have to be notarized. It is a valid will. Now, for the statutory will, there are requirements, okay? The first requirement is you must name all of your children, living or deceased. So in other words, let's say that you have 3 children. One of those children died in an automobile accident 5 years ago, and that deceased child has left 2 children. You have to name the 2 children, you have to name the predeceased child, and you have to name the 2 children that were left by the predeceased child. Okay? Does not mean that you have to leave them something. Another common myth is, okay, I'm going to leave them $1. $1 love and affection. No, you don't have to do that, okay? There's only one person in the world you cannot disinherit, and that's a surviving spouse. You can disinherit your children, you can disinherit anybody in the world, but you cannot disinherit a surviving spouse. They have what's called a statutory election. They can elect to receive what they would have gotten if you died without a will. But you do have to name them. If you don't name them, then they are called an omitted heir. Okay? Let's say that you have 2 children and one that's passed away, leaving the 2. But one of the children that is still living took off 20 years ago, and you haven't heard from him since. And you're just, your attitude is, they're dead to me, all right? So in your will, you just name the one child and the predeceased child in the two. Guess what? The omitted heir now can come back and claim whatever he or she would have gotten if you had died without a will. They get their share first before the will kicks in. So you have to name children, whether they're living or deceased, and any children left behind other than that. You can, again, you can leave your property. If you have minor children, then you can nominate somebody to be the guardian of the children. You cannot, your nomination is going to be advisory only. A court is not going to be bound by your nomination. I hear this a lot. People come in and they say, you got any children? Yeah, I've got an 8-year-old. Okay, where's 8-year-old's father? Well, he's not in the picture. Those are the words I hear. He's not in the picture. I hear those words a lot. And I say, but where is he? Well, he hadn't seen the child since the child was 6 weeks old. Don't care. Where is he? But he's never given the child a birthday present, a birthday card, a Christmas present, anything. I don't care. The Constitution says he's number one. And you cannot do that. 13-year-old child, never seen her father before. He's number one. You cannot change that. It leaves a bitter taste in a lot of mouths, but you cannot change that. Okay? Biological parent, unless their rights have been terminated judicially, they have a constitutional right to the relationship with their child, whether they've exercised it or not. Okay? So you cannot do anything about it. You can nominate somebody. Now, let's say the biological parent is dead and you nominate your sister to be the guardian. That doesn't mean that the sister's automatically going to be the guardian. Somebody can come in and petition the court either to be the guardian or to adopt the child. And then sister and this other person are in a battle to determine who's going to be the guardian or the adoptive parent of this child. The court has one standard and one standard only: best interest of the child. That's what happens. Now, when a child gets to be 12 years old, they can name a preference to the court, and the court is obliged to listen to the child, but still not obliged to follow the child's wishes. If a 12-year-old or older child expresses a wish for custody, then the court has to listen to the child, and if doing something different than what the child wants, has to state specifically the reasons that it went against the child's wishes. That's gotten a little more, And I think, as most of you know, if you look at the headlines, if the child is eligible for tribal enrollment, that can create all sorts of nasty things. So those are issues. You can nominate someone, but your nomination is not going to be, is not going to trump a biological parent, and it's not going to get away from the court's granting of custody based on what's in the best interest of the child.
So is that where the grandparents come in too? I mean,
the grandparents can come in. Usually there is preference for a biological relative. But when you get to grandparents, sometimes it becomes an issue of, are the grandparents too old to take care of a child this age, or, you get into other issues like that. But a family member usually is preferred. And a strong preference is usually given to a family member that has an established relationship with the child, usually. But
so if like I was babysitting my granddaughter and something happened with both the kids, both the parents.
Right.
And I mean, like, we all get along, so
right.
Could there be like a joint custody with the grandchild with both sets of parents?
You know what, I've not actually seen that, but I don't know of any reason why there couldn't be. I don't know why a paternal and maternal grandmother, for instance, could adopt the child and have a joint custody arrangement under that. I don't know why it couldn't happen. I personally have never seen it and truthfully hadn't thought about it. But you can also have an adoption where, let's say for instance, are you the mother of the mother or mother of the father?
Mother.
Okay, you're mother of the mother. Okay. You could have a situation where you and your husband could adopt the children, and the adoption court grant specific custody or visitation rights to the father's parents. In other words, you can have more or less what's called an open adoption and grant visitation to them that is court ordered and enforceable. So, I mean, yes, you can both get enforceable rights from it.
Well, I mean, not that we would, I don't think we would ever have an issue with that, but we're native and they're not.
Well, and, you know, and then you get into the issue of the tribe has to be notified and the tribe has to be involved, and the tribe can transfer it to a tribal court, you know, and so you could end up in a tribal court over it. So
I don't think there would ever be an issue, but I just thought, you know, if that would, you know, good Lord, I hope that we could join.
and you know what, I've not actually thought about it, but truthfully, you're right, it probably could be. If, you know, and again, the tribe would have to be involved in that decision. So. Okay, we've talked about wills and the requirements for a will. Okay, when we talk about the requirements for a will, if you're doing a statutory will, not the holographic will, if you're doing the statutory will, it must be witnessed by at least two people who are not related to you, who are not heirs, who are not, you know, who do not stand anything to gain anything from your estate, and it must be notarized. Okay, now that alone will be a valid statutory will. If that's all you have, then if that will is admitted to probate or offered for probate, in order for the court to accept it, one of the two witnesses, at least one of the two witnesses, is going to have to come to court and testify. Yes, I was there. Yes, I saw him sign it. That sort of thing. But then you can have an additional paragraph afterwards called the self-proving, and it involves another set of signatures and a notary and that sort of stuff. And if you have the self-proving will, then that can be offered without the need for a person to come forward if it's going to be admitted. Okay, any questions about wills? Okay. I want to take a few minutes and talk about trusts. This is something that I get a lot of questions about. And normally when someone comes to see me, here's what I get. Well, I went to a seminar last year and they told me that I just had to have a trust. I said, really? Who gave the seminar? Well, some guy that sells trusts. Yeah, okay? What I find is that most people don't need trusts, but trusts are nice. Trusts are expensive, but no more expensive than a probate. Now, trusts are used in a couple of different ways. First of all, you have what's called a testamentary trust. Now, a testamentary trust is a trust that is actually built into your will. Okay, so almost always, all or part of your estate that's passing through your will, if you have a testamentary trust, is going to be passed to the trust. Then you can have a standalone trust, which is called an inter vivos or a living trust, which is a separate document from your will. Now, a trust is actually a legal entity, okay, like a corporation is a legal entity. It acts through what's called a trustee. The trustee is the person that administers the trust and invests the property, pays the money, and does all of that. So if you've got a husband and wife, what typically you have is this. You have a trust where, while both parties are still alive, those parties, the husband and wife, are the trustees. If one of them passes away, the survivor is the trustee. Then when the survivor passes away, you've nominated or designated someone to be the successor trustee after both of you are gone. The people that create the trust are called the trustors or the grantors. Okay? The people that are ultimately going to get the benefit of the trust are called the beneficiaries. And the people, or the person that administers the trust, is the trustee. So John and Mary can have a trust, put their money in the trust. The trust will actually own the money, or own the property. If you have a house, you will deed that house to the trust. You have the John and Mary trust. Okay? So after the trust is created, John and Mary do a deed from John and Mary to the John and Mary trust. Now John and Mary trust owns the land. And whoever the trustee is has the authority to convey the property, mortgage the property, or do whatever. While John and Mary are still alive, that'll be John and Mary. So it's transparent. John and Mary just keep on doing what they're doing. It's just they do it in the name of the trust instead of their own name. And then when John and Mary are gone, they've nominated someone who can then distribute the property the way they want to distribute it. So why would you want to have a trust? Well, there's a couple of different reasons, main reasons. One is if you are in that really, really high tax bracket, one of these days, one of you may get there, and if you do, the trust is a way to avoid death taxes, okay? If you are up in that area, more than 5 million apiece or 10 million for a couple. Another reason you might want to have a trust is if you want to control the distribution, okay? Let's say you have an estate worth $500,000 and you've got 2 kids that are ages 18 and 20. I ask, okay, you've got a net estate of $500,000. You've got an 18-year-old and a 20-year-old. How comfortable are you dropping $250,000 on an 18-year-old? Okay? How comfortable are you with that? And not very. Okay? All right, so when you create a trust, you can control the payout. You can say they will get it at $1,000 a month. You can say they will get it, X amount of dollars when they graduate with a bachelor's degree, or they will get X amount of dollars, when they reach 30 years old. Okay, I've done this for 27 years, and just within the past 8 months or 10 months, for the first time I heard this, and I think it's brilliant. A couple came to me, wanted to do a trust. We're setting up the trust. And I said, how do you want the payout to your kids? Said, they bring a paycheck to the trustee and we'll match it dollar for dollar. Every dollar they make will match. But in order to get a dollar, they've got to earn a dollar. They've got to understand what it means to go to work and earn money. Okay? So they had it set up so that, and I just thought that was brilliant. That's perfect. A lot of times you want to leave money to a grandchild, maybe a grandchild that's 4 years old, 5 years old. So you want to invest for that child's college education. So you have a trust to pay for college, or to pay for a car when they turn 16, or to pay for whatever. I've had people come in and want to pay for weddings, want to pay for cars, want to pay for college, want to pay for that sort of stuff. You can't do that with a will. With a will, there's an automatic payout. It happens. Now, a will with a testamentary trust, you can do that, but you have to have that trust set up. A trust can be revocable or it can be irrevocable. Now, you get into some pretty strict rules. By being revocable, that means you can revoke the trust at any time. You can take the property back out of the trust, resume ownership of the property. Usually, the irrevocable trust, again, is for the higher tax brackets to avoid taxes. If you put it in irrevocable trust beyond your control, it is beyond the control of creditors. It is beyond the control of other people. At one time, and forgive me because I've not kept up with this, but at one time, if you put property in an irrevocable trust and it stayed there for more than 5 years, and then you went into a nursing home, DHS couldn't touch it. Now, I think DHS has closed a few loopholes and made it impossible to do that anymore. DHS and Medicare, Medicaid, they have a 5-year look-back period. Okay, they can look back at property that you've owned for the past 5 years, and they can count you as owning that property now for purposes of value. You can't have any more than $2,000 in property, and you can only keep so much money of your Social Security and that sort of stuff. So if you sold a house and put it in an irrevocable trust, and they'll look back, if that's been in the past 5 years, they can look back that 5 years, and they will charge you with all of that, and it will get ticked down at your monthly rate until it's used up. So it's a real convoluted scheme, and if you have issues, I suggest that you consult with an attorney that deals with benefits law, because that's a specialized area. Another purpose for trust is what's called the supplemental needs trust. This is if you are leaving money to a person who is mentally disabled and you want to do this. This is a way of leaving them property without messing up their benefits. Okay? Medicare, Medicaid, or whatever pays to developmentally disabled people, they provide certain things. If you provide a trust for that developmentally disabled person that provides them for things other than what Medicaid provides, then you're not messing with their benefits. Okay? The Medicaid rules say, the Medicaid rules say that a trust can buy this person a house and not mess up their Medicaid benefits. Okay? I believe you can buy them a car and not mess up their Medicaid benefits. Okay? You can't buy them $1,000 worth of food a month because, that would mess up. You can't do other things, otherwise they're going to, but you stay within the guidelines, and you have what's called a supplemental needs trust, and you can draw that so that it says that the trustee is authorized to spend the money for anything that won't mess up the beneficiary's benefits, and leave absolute discretion to the trustee. With a trust, you can have as much or as little discretion to the trustee as you want. Okay? You can give them complete discretion to do whatever, just blank check in effect, or you can say we only want it spent this way, and only to this extent, and only to this amount. You can control how they invest it, how conservative they have to be. You can say municipal bonds and nothing else. You can say, hey, look, if you find a hot penny stock, jump on it. You can do whatever you want. It's your money, you can do whatever you want with it. So you can give as much or as little discretion to the trustee. Another thing I tell people when they come in, and whether they make a will or whether they make a trust or whatever, I always say, look, you need to have a discussion with the beneficiaries. I mean, most of the time, your kids. You're leaving money to your daughter. You're leaving money to your son. And to be quite honest, it's most often leaving money to their daughter that I get this question. They come in and they say, if I leave this money to my daughter, can my son-in-law get any of it? That's what they want to know, okay? So here's the deal. If you leave money to a person, a married person, that gift is their separate property. It will stay their separate property as long as they do not do anything to it that will convert it to joint property. So, the sad reality is, and I know this as a parent, there's nothing I can do about it, okay? If I leave the money to my two sons, I can't control what they do with it once they get it. I can't say it's yours as long as it stays separate. Okay, I can't do that. It's an unconditional gift. All I can do is say to them, look, When you get it, it's your separate property. And you need to go talk to a lawyer and find out what you can and can't do to make it, to keep it separate property. You need to do that. When my mother-in-law passed away, my wife's brother and sister came into town from, he came in from Illinois, she came in from New Jersey. And we met at my office, and we gathered around the conference table that I have in my office. And we were talking about what the assets were and how they were going to get divided and that sort of stuff. And at one point I said, now I want you all to understand, when you get this money, it will be your separate property. And my sister-in-law immediately said, I've already asked an attorney about that. So, I mean, you know, that you got to be heads up. You got to be heads up. So with a testamentary gift is a separate property when you give it. So. Okay, questions about trusts? Okay.
Yes, I'm in the mortgage business, and I deal with FHA exclusively. That's one of the reasons I'm here. I specialize in the reverse mortgage programs. So,
Okay.
So everything's FHA, and I deal with a lot of folks that have a trust. And because of some changes that just have happened in FHA and just mortgage in general, an attorney needs to review a trust as long as it's revocable.
Right.
So my question to you, the reason I came is to find out, is that something that you could do? You're basically reviewing the trust. My understanding is you're reviewing the trust just to make sure that if there's a mortgage, that having the mortgage doesn't affect the validity of the trust or change any of the terms.
Okay. Okay. And I understand that sometimes there's an issue when trusts are created that a mortgage company sometimes gets a little skittish because they're afraid they might lose some priority. And in that regard, certainly I can look at those mortgages. Now, as far as impact on changing FHA rules, I mean, I'm going to cautiously say yes, I can do that. But I'm also going to, run back to the books and make sure that if FHA has changed things that impact, none of the sources that I have seen in the real property materials from the Bar Association and in the probate and trust section, none of the materials that I have seen given me a red flag about materials from the Bar Association and in the probate and trust section. None of the materials that I have seen have given me a red flag about FHA mortgages. So if there's something out there, quite frankly, I'm not on it right now.
Well, I can send you. Your email. I'll send you an outline of the changes. I'm just. I'm looking for some. I'm very protective of my senior. I'm very protective of the people I work with.
Yeah.
And I try to make sure that they go to someone that.
Right.
I'd have work with my mom or my dad. So.
Sure.
So I want to. And I'd like to send it to you and see if it's.
If you'll send me the outline, it would do me good to look it over just to make sure that I'm up on it.
Okay. Thank
you. Just because I'm the one conducting the seminar doesn't mean I can't learn something here tonight too. So, and sometimes. And it's better for me to learn it this way than to learn it with someone coming in and me missing it and finding out the hard way that I missed it. Okay. I want to take just a minute. I know we're actually running a little over, and I apologize. But I want to talk because some people want to hear about powers of attorney. This is an issue for people. You need to. Here's what I tell people about powers of attorney. A power of attorney is a document where the person gives the power to another person to act on their behalf. The person that is appointed is called the attorney in fact. Okay? And so the attorney in fact can be given a broad discretion of abilities in a power of attorney. A power of attorney can either be general, which means it takes effect immediately when you sign it and continues in effect until either you revoke it, or you die, or you lose your mental capacity. Okay? Or it can be durable. That means it does not take effect right now. It only takes effect if you lose your mental capacity. And then it continues in effect either until you regain your mental capacity or until you die. Okay? Then you have the hybrid, general durable. It does both. It takes effect immediately. It continues in effect even if you lose your mental capacity. It will cease to be effective if you revoke it while you have your mental capacity or if you die. Now, have you noticed the one common element in every single one of these? That is, it ends when you die. I get lots